Hello everyone, I'm Anuj Nakade and welcome to livelaw. We bring you news about the ongoing litigations regarding the disputes over governance between Delhi's Lieutenant Governor and the Legislative Assembly of the Government of the National Capital Territory of Delhi, led by Arvind Kejriwal. As you know, Delhi is not a state, it is a union territory. States in India have their own legislative assembly that forms the state government and has their own executive who enforces their laws. Union territories, on the other hand, are run by administrators appointed by the President of India, who are the executive heads of the central government. But unlike most union territories, Delhi has its own legislative assembly. Delhi has a special situation where it has an elected government in the legislative assembly, and it has the executive control by the President through the Lieutenant Governor. The story of the disputes between the Delhi government and the LG start in 2014, when the Delhi government went to the Delhi High Court for the control of administrative services like electricity and the appointment of public prosecutors and so on. The Delhi High Court decided that Delhi, while having its own legislative assembly, still remains a union territory, and so the President continues to administer it through the LG, curtailing the powers of the elected government of Delhi. The Delhi government then approached the Supreme Court, and a two-judge bench of the Supreme Court decided that the powers under the Commission of Inquiry Act, along with the powers of the Anti-Corruption Bureau and the police powers, will remain with the Lieutenant Governor. The two-judge bench, however, decided that the Electricity Board and the appointment of the public prosecutors was a power that should be with the Delhi government. However, the issue of services in the state list mentioned in Schedule 7, List 2, Entry 41 was referred to a three-judge bench. A three-judge bench then referred it to a five-judge constitutional bench. Earlier this year, on the 11th of May, the constitutional bench ruled on this matter, saying that all services except public order, police and land must be under the government of NCT Delhi. The judgment reads, and I quote, NCTD has legislative power over services excluding public order, police and land under Entry 41 in List 2. The Lieutenant Governor shall be bound by the decisions of the GNCTD on services. We extensively covered the arguments made by both sides, the full procedural history of the issue and the judgment in a previous video, which you can watch through a link in the description. However, soon after the judgment, on May 19th, the President of India introduced the Government of National Capital Territory Amendment Ordinance of 2023. This ordinance in effect deprived Delhi government of the power over services, which essentially is contrary to the judgment of the Supreme Court. The ordinance in question envisions a committee comprising of the Chief Minister and two senior bureaucrats, which will make recommendations to the Lieutenant Governor regarding transfers and appointments of civil servants, and then the LG will have sole discretion in taking a decision. As a result, the Delhi government then approached the Supreme Court with a writ petition challenging the Government of National Capital Territory of Delhi Ordinance. The petition points out that ordinance was brought out a week after the Constitution Bench of the Supreme Court pronounced that the Delhi government has the power over Entry 41 List 2. The argument is that the ordinance was promulgated by the central government to overturn the Supreme Court's verdict. The Delhi government argues that this ordinance negates the principles of federalism and the primacy of elected government. The petition says, and I quote, the principle of collective responsibility in a democracy incorporated in Article 239 AA6 requires that the elected government be vested with control over officials posted in its domain. In the federal context, this would require that such control be vested in the regional government, that is GNCTD, under Article 239 AA for matter in its domain. This essential feature was secured for the GNCTD by this Honorable Court in 2023 Constitution Bench judgment and is now sought to be undone by the impugned ordinance. A bench comprising Chief Justice of India D.Y. Chandrachud, Justice P.S. Narasimha and Justice Manoj Misra heard the petitions between Government of NCT Delhi and the LG of Delhi today. The bench observed that the present issue in the petitions challenging the ordinance is whether the powers under Article 239 AA7A of the Constitution could be invoked to make the law of this nature. Article 239 AA7A allows the Parliament to make provisions for giving effect to supplementing the provisions contained in the foregoing clauses of Article 239 AA or for matters of similar nature. The court also observed that this issue has not been considered in two previous Constitution Bench judgments on the issue, both in 2018 and 2023. The CGI said, and I quote, "What they've done is that by using power under 239 AA7, they've amended the constitution to take services out of Delhi government control. Is that permissible? I don't think either of the Constitution Bench judgments has covered that." The Solicitor General of India, Tushar Mehta, appearing for the Union of India, pointed out that as per Article 239 AA7B, a law made by the Parliament in terms of Article 239 AA7A is not deemed as an amendment to the Constitution. Earlier, as soon as the matter was taken up, the SG urged the bench to defer the hearing in view of the fact that the ordinance is going to be presented as a bill before the Lok Sabha in the monsoon session starting on the 20th of July. He said, and I quote, "It is possible that the ordinance may be passed in a different form after the parliamentary process." Senior advocate Harish Sarve, appearing for the Delhi Lieutenant Governor, submitted that the issue was regarding the competence of the Parliament to make the present law under Article 239 AA7A, and since it was not an issue considered by the earlier Constitution Bench judgments, a reference to the Constitution Bench was necessary. Senior advocate Dr. Abhishek Manu Singhvi, appearing for the Delhi government, submitted that he is opposed to the reference and sought an opportunity to argue against referring the matter to a constitution bench. This was not the only dispute between the Delhi government and the Lieutenant Governor which was heard by the court today. Before hearing the dispute over the ordinance, the court also heard another ongoing dispute between the LG and the Delhi government over the appointment of the Commissioner of the Delhi Electricity Regulatory Commission, or the DERC. This dispute started on the 9th of January this year. The chairperson of the Delhi Electricity Regulatory Commission and retired Allahabad High Court judge, Justice Shahibul Hasnain, left office after completing 65 years of age. So, the Delhi government placed a proposal to appoint Justice Rajiv Kumar Srivastav, a retired judge from the Madhya Pradesh High Court, before the Lieutenant Governor of Delhi on the 4th of January, 5 days before his retirement. However, no action was taken on the proposal made, and the DERC continued to function without a chairperson for 4 months. The LG then stated that he is in need of legal advice on whether the opinion of the Delhi High Court Chief Justice is needed for accepting the Delhi government's proposal. So, in April, a petition was filed by the NCT of Delhi against the inaction of LG in approving the proposal. Then, in May of this year, the Supreme Court clarified that as per the Electricity Act, that concurrence with the opinion of the Chief Justice of the High Court of that retired justice will be required, and there is no requirement of the concurrence with the Chief Justice of the Delhi High Court. After that, the LG went on to appoint Justice Umesh Kumar, a retired judge from the Allahabad High Court, as the DERC chairman. The statement issued by LG states that the retired Justice Srivastav, who was recommended by the Delhi government, expressed his inability to be appointed as chairperson due to family commitments and requirements in a communication to him on June 15th. The Delhi government then filed a petition in the Supreme Court challenging the appointment of the retired Justice Umesh Kumar on the ground that his appointment was made unilaterally by the Lieutenant Governor without the concurrence of the Delhi government. Previously, the Supreme Court had deferred the oath-taking ceremony in this case till the matter is resolved in the court. We covered the previous hearing in this issue as well. We will leave a link in the description to that video in case you'd like to watch it. Today, the three-judge bench wondered if an amicable discussion could bring about a solution to the problem, and if every problem between two constitutional functionaries needed to be resolved by the Supreme Court. The court said, and I quote, "Should everything work through the modalities of the Supreme Court? Can the Lieutenant Governor and the government sit down and decide on the name of the chairperson of the DERC? They're constitutional functionaries. They have to rise above political bickering. They have to come up with an agreed name." Senior advocate Dr. Abhishek Manu Singhvi, representing the Delhi government, agreed to get instructions from the clients on the matter, even as he expressed lack of optimism in resolving the impasse without the intervention of the Supreme Court. Senior advocate Sarve, appearing on behalf of the Lieutenant Governor of Delhi, expressed disapproval of the pessimistic approach of the Delhi government. He said, and I quote, "It is unfortunate that the Delhi government lawyer starts by saying that he has no hope. The first reaction should be, yes, we'll do it." The bench has posted both the matters to be heard again on Thursday for further instructions. Both parties have been instructed to consider resolving the issue of appointment of the DERC commissioner by the next date, and the court will further consider forming a constitution bench to hear the challenge to the ordinance by the president. That's all we have for you in this video. Hope you found this video informative. If you did, please leave a like. And tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. If you want to read the judgment or find articles about it or get our latest updates, please visit our website at www.livelaw.in. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.